Hello students, welcome to PW OnlyIAS. I am here Harpreetsir with the daily analysis of the Hindu from 2nd of November 2024. Let's begin with today's analysis. What all topics we have taken for today's analysis? The MLA disqualification. So what are the criteria and premises on which a MLA, Member of Legislative Assembly, can be disqualified? Page number 2, spousal privacy. Very interesting topic which we're going to discuss. The judgment has been given by the Madras High Court. Page number 2. PMEAC, Economic Advisory Council, page 3, COP16 and Methane Diplomacy, which is basically your editorial. Then we have for the prelims, GST receipts rise in page number 1 only, AQI, Air Quality Index. Then we have the Nilgiri Biosphere Reserve and the Hwasong 19, which is intercontinental ballistic missile by North Korea. So we'll be seeing certain features of that. Let's begin with today's analysis, main topics. So what is mentioned in Topic 1, this is relevant from the perspective of GS paper 2. Page number 2, MLA disqualification. Now please understand over here, it is mentioning majorly about defection related dimensions. But for us, when we are analyzing a topic, we need to analyze on what all grounds can a MLA be, let us say, disqualified and what are the dimensions associated with that. And then we'll come on to this article and see that, right? Let's move or study the disqualification dimension. See. In the constitution itself, certain dimensions have been written under which a member of legislative assembly can be disqualified, and there are also laws also, Representation of People Act, under which also provisions are there for the disqualification. Now see, according to the constitution, under Article 191, a person shall be disqualified as a member of legislative assembly or for that matter, member of legislative council if he holds any office of profit under the government of India, state or the office declared by law of the state. Now we will see what is office of profit, but right now just understand if he holds any office of profit, he can be again disqualified. Any competent court declares any member to be of unsound mind. That means now mentally sound, then also he can be disqualified. If he charged cheated and bankrupt or insolvent, if he is not a citizen of India, if he has voluntarily acquired the citizenship of a foreign state and under an acknowledgement of the allegiance and adherence to the foreign state. So that means he's giving up his citizenship. So automatically under this, he will not be a citizen of India and can be disqualified. Now see, the topic over here is one of the provision under the constitution is holding an office of profit. So what office of profit means, please see here. The term office of profit has not been defined in the constitution. It is simply written that a person holding an office of profit, but it is not defined. So please see. But remember, Article 1021 and 191, which give effect to the concept of office of profit, prescribes restrictions on central and state level on lawmakers accepting the government position. So they are just stating that office of profit is office of profit with respect to the member of parliament and member of legislative assemblies, or for that matter, MLCs also. They should not be holding office of profit. But now constitution does not define it. So what is office of profit when we are dealing? So there are certain principles based on which we analyze that the person might be holding an office of profit. See, principles of declaring office of profit. 4 broad principles evolved for determining. See, evolved, that means which time it evolved, that these can be an office of profit because constitution does not define it. Evolved while determining an office attracts the constitutional disqualification. See, whether the government exercises control over the appointment, removal and performance of the functions of the office, whether the office has any remuneration attached to it, because after remuneration the person can extract extra income, whether the body in which the office is held has government pass, that means releasing money, allotment, licensing, because if a person has that extra power over there, then he can earn money through, let us say, allotment, giving licenses and all. So that means, simple words, we'll be seeing what office of profit is. Whether office enables the holder to influence a way of patronage. Now see, this is telling about the principles. Like in a way, when you read these principles, you are trying to see that a person who is, let us say, an MLA, MLC, for that matter, at the parliament level also, the member of parliaments, if they are a member of parliaments and they are holding these offices in which they can, let us say, get remuneration, income, or let us say, or through which they can earn income, let us say, something that is not allowed. So what happens? What happens under the government office? So what happens is that is declared as an office of profit because you are basically in a position of getting remuneration, or directly or indirectly. Indirectly means supposingly you are occupying a government office, let us say, where you have the power to grant licenses. So that means by default there's a probability you can indulge in corrupt practices. So these are certain principles that over the time have evolved. These have even been taken from the these are present in the Lok Sabha and Rajya Sabha Secretariat also, and at the Vidhan Sabhas also, right? Now, these principles basically determine whether that person is holding an office of profit or not. If he or she is holding, then you will be automatically disqualified. That means that out of the purview of the duties that have been or you are bestowed on you as a member of parliament or member of legislature, assembly or council, you are drawing certain other benefits from the government offices which might be outside the purview of the office that you are holding. That is why this is again the dimension of office of profit. Now coming back again, any office of profit under the government of India or the state, that means you are, let us say, other than holding the position of MP, MLA, whatever, you are also holding a position where you are in a position of holding an office of profit, because that means you can profit out of that position. That is why the word office of profit is mentioned here, right? This is something mentioned in the Constitution of India. Now, please remember, under Schedule 10, that is anti-defection law, which you had basically studied, we had discussed in the previous lectures also. Under that also, one can be disqualified. An elected member voluntarily gives up the membership of a political party. That is one ground. An elected member votes or abstains from voting a such contrary to a direction issued by the political party or any authorized to do so without prior permission. We had already studied this in the previous lectures also, where in these two cases also, he or she can be disqualified. Next, according to the Representation of the People's Act 1951, a person shall be disqualified as a MLA or MLC if, please see, if one is found guilty of an illegal practice in the election related to election. That means if you are basically indulging any corrupt practice or illegal activity during the process of election, you can be disqualified. Second, a person is convicted of an offense, sentenced to imprisonment for various terms under the section 8123. That means there are various laws under which, sections under which, if you are sentenced under that, that means you will be disqualified. So due to some imprisonment clauses also there. Now, this is again the second, in fact, the third dimension under which one you can be disqualified. One is it in the Constitution. One again in the Constitution under the Schedule 10, that is the Anti-Defection Act. Then you have the Representations of People Act 1951, under which also you can be disqualified. Now what happens, please understand. In the particular case that has been mentioned, that is related to the anti-defection, right, law, that is defection of a political party to the other party, or the members of one party to the other party. Now generally what happens is that there are certain exceptions that are given in the anti-defection law. And misuse of that law is basically being taken as a leverage or a privilege, where basically people try to shift from one party to another in bulk. And that is why then the issue of, that means the spirit of what the anti-defection law was not being fulfilled. Now see, exceptions under anti-defection law. See, in a situation where 2/3 of the legislatures of a political party decide to merge with another party. Understood? See here, let us assume there are 60 members, please see here, 60 members of a political party P1, clear? And there is another political party which has, let us say, 60 members. Now, 2/3 of the members of this is 40. Now, supposingly, if the 40 members go and join this and merge with them, then they will not be disqualified because it is treated as a merger. Now what happens? Now this is like a wholesale defection is allowed, but individual defection is not allowed. So this is what is happening in the case of Goa also. So see, neither the member who decides to join or the ones who stays with the original party will face disqualification. So that means individual level disqualification will be there if supposingly 2 or 3 people out of the 60 go and join this political party P2. They will be disqualified. But do you realize that 40 members, if because it's meeting the 2/3 requirement, they leave this political party and join that. That means that is absolutely fine. There is no issue in that. So it is means a wholesale defection or a wholesale defection is allowed. It will not, there will be no disqualification. So this is what is basically happening in the case of Goa also, right? That is why please understand these issues do arise. Another is any person elected as chairman or speaker can resign from the party and rejoin the party. Obviously, the person is elected as a speaker. In order to maintain its neutrality, a person can leave the party for the timing. He or she will not be disqualified. Earlier also there was a law in which law allowed the parties to split, but at present this has been removed again. So this is not relevant. These 2 points are relevant. Now another point of bone of contention is the deciding authority. The speaker is the deciding authority. Any question regarding disqualification arising out of the defection is to be decided by the presiding officer of the house. So now, very often the role of the speaker or the presiding officer also comes into question, because though they may represent to be neutral, but they also had been belonging or elected as a member of parliament or legislative assembly from a political party. So then what happens is there might be again issues of partiality being observed. So what happens then, you tend to favor the political party from one has been. So these are certain questions that have been raised to various observations that have been made. So similarly, what we realize that the role of the presiding officer also becomes a bone of contention, which is again in the case of Goa. So these two dimensions over here are a point of concern which we see here, and that is why this can be asked with respect to the role of the speaker also, with respect to the loophole that is present in the anti-defection law also. So these are the cases which is important for you. That is GS paper 2. Let's move ahead. Spousal privacy, a very, very important. See, this is important from the GS2 perspective, right? GS2 perspective. Now, see, we will be seeing what the judgment also is. Right now, let us see, as more and more editorials will be coming, we'll be analyzing it in more detail also. We'll be seeing certain dimensions of this. Before we go on, spousal privacy is a fundamental right. Evidence obtained by violating is inadmissible. Firstly, you need to understand what is spouse, right? Normally, when I use the word husband, that means a man and a wife is calling that person because that lady is married to that man, right? Husband. Wife, that means from the perspective of a man, that she is a female and married to a, let us say, a boy, a man. But when we talk about spouse, it is a gender neutral term. A man might be saying that she is my spouse. A woman might be saying he is my spouse. That means it is talking about a marital relationship without mentioning the gender. So it is a gender neutral word. That is to be understood very well, right? So it is a gender neutral word. So that means when we're talking about spousal privacy, that means you will get a brief idea that though the people are married, let us say right now we are assuming what is allowed in the Indian society and under the constitution and the laws. Let us say a husband and a wife, they are married, they also have their own privacy. That means, for example, the conversation that they have on their phones with other people and all. Now, supposingly, if you assume that someone assumes that the person's wife is cheating on that person, and you, let us say, hack the phone of a particular your wife, and you take out the data and present it in front of the court. The court says this will not be admissible because you have violated the rights of your wife. Similar case would be for the wife also, if the wife does for the husband. So that is why it is not mentioned wife's privacy, it is mentioned spousal privacy. Many people will take it in the wrong way. But one should understand that this is, though the case came where the women had complained about his wife, but this is for the man and women both. So we'll understand this after some time. First, let us see what privacy is. Let us see how it has become a part of the fundamental right. And then we'll come on to this aspect of the Madras High Court, which has been presented over here. Let's see. Now, I have taken the definition of privacy. Rather, there is no perfect definition of privacy right now. You would be seeing that this is from the Lok Sabha Secretariat. Now see over here, a definite legal definition of privacy is not available. We know that very well. So some legal experts, that means because it is itself an official document, so that is why I'm using it. It's a privacy as a human right enjoyed by every human being by the virtue of his or her existence. What is privacy? Privacy is a human right enjoyed by every human being by the virtue of his or her existence. It depends on no instrument or charter. That means it is not dependent that this is the statement I've given and this is only privacy. No. It is an ever evolving process. It is a subjective also based on society to society. So privacy can also extend to other aspects, including bodily integrity, personal autonomy, informational self-determination, protection from state surveillance, dignity, confidentiality, compelled speeches and freedom of dissent, move to think. So all these things are basically can be a part of your right to privacy. Over here, confidentiality is also written. That means I don't want to disclose something. Now the certain issues also come. We will be seeing that, right? We'll be seeing that. And let's see. Now comes again another part. Please understand Supreme Court's verdict on right to privacy. Before we go and understand what the article says, these are certain things that you should be knowing, right? Right to privacy have always been, we've been hearing. So we need to understand when was this right recognized as a fundamental right also and emphasized. Please see, in a 9-judge constitutional bench headed by Justice J.S. Khekar, on 24th August 2017 gave a landmark decision on the right to privacy. The Supreme Court ruled that right to privacy is intrinsic to the life and personal liberty and protected under Article 21 as a freedom guaranteed by the Constitution of India. So you would have seen this, that this is a very, very important decision that had been taken or judgment given by the Supreme Court. Under this, now we know that right to privacy is a part of your Article 21, which is basically right to life and personal liberty. Understood now? Now comes the aspect. We have understood what is privacy. We have understood how it became actually one of the major judgments. See, there have been earlier judgments also. Those were basically stating like intervening something is no against, let us say, liberty, personal liberty. So there have been various Supreme Court judgments to be, but this right to privacy exactly as a part of your Article 21 was very categorically stated in this judgment. That is why this judgment becomes important. It is not that directly or indirectly the Supreme Court has mentioned about the importance of privacy. They have mentioned certain dimensions which lie under Article 21. But more a proper emphasis was given and a proper judgment was given in 2017. Right? So now comes the issue, what is the Madras High Court's view has been? When we go to this article over here, spousal privacy is a fundamental right. Evidence obtained by violating is admissible. So see, we need to know a brief idea about it. We don't have to go into R&D. As more editorials come, we'll be analyzing it also. See, the Madras High Court says that, let us say, a person, let us say husband or wife. Let us take, this is a wife, a husband. Now she has her own gamut of life, both having cell phone, right? Cell phone. Both talking on WhatsApp, talking over the call and meeting people, whatever be the case, right? Now, the Madras High Court says what the case actually happened. Understand this. The man who basically filed the case, he said that the husband had a doubt that wife was indulging in some, let's just say, extramarital affair or wasn't having an affair. This man got the call records of his wife, right? So, got the call records. From the call records, he got an evidence that yes, that his wife is having certain extramarital affair. Now he went to the court. Based on this, he went to the court. Madras High Court. Now in the court, the wife says that this is incorrect. This is incorrect and against my privacy. That means, see, understand, there are certain contexts in which one might be talking to some friend or let us say somebody In what context it was talking, you might not be knowing. This is what the pretext of the wife is. The wife says, no, I was talking, whatever, but how can he present my call records and take out and present in front of the court? This is against the law. This is illegal. This is against privacy. But on the other hand, the husband says that I am doubtful that you are indulging in an extramarital affair. That is against my your integrity, and for that matter, the integrity of the marriage. But what the judgment came is something very interesting over here. The judgment that came is the Madras High Court says that the husband, in case it can, the condition can reverse also, please understand, because it is spousal privacy, the situation can reverse. Even the wife can do the same thing, the similar thing will apply. So what the Madras High Court says is that the Madras High Court says that this evidence cannot be accepted. Cannot be accepted. Why it cannot be accepted? Because in the 2017 judgment, we talk about right to privacy as under Article 21. Now see, as right to privacy is fundamental right under Article 21. Now, taking out the records of your wife goes against the right to privacy of the wife. And that is why he said over here, see, did you understand what the Supreme Court says? You need to, the High Court says, you need to understand that though the fundamental rights are given, it depends upon the judgment which right is given more preference or an upper hand. Over here, the issue of privacy was given more preference than the concern that the husband was raising. So the court said that we cannot accept the call record because you did not ask your wife to give the call record. So that means there was no consensus. That means a person whose call record has been taken, the consensus has not been taken. So that means it is against the right to privacy and we cannot proceed ahead with this case. That is why the case was dismissed. And over here, a judgment was given that over here, that spousal privacy is a fundamental right, and evidence violating them is inadmissible. We cannot admit that. We cannot accept it. So there is no point in the case. Now, the problem arises over here that there has to be a balance between right to privacy and along with the concern that the spouse is having, over here the husband. Now, how does one prove that the wife, or let us say any for that matter reverse case can also happen, that how is a person will prove that, file for divorce, that the wife or the, let us say the spouse is indulging in some extramarital affair. Now, what the question arises is, supposingly if let us say the wife is with her, let us say boyfriend, and the husband clicks the photograph, that can also be a violation of right to privacy. But that will not be admissible in the court. So there are concerns in this judgment. Concerns with, there has to be a proper mechanism. So what they said, that a certifying authority should be there, where let us say if a call record is being from basically being, if you want a call record, from the call records you have got, that should be taken from a proper mechanism and channel where the certification should be there that yes, this is a call record of the wife, and along with it the consensus of the wife should be there. Now this itself again raises concerns that whether a certain secretive activity that is going on, which is basically against the law of the marriage over here, that will not be acceptable in case of the court, because the right to privacy is being given preference. One more thing that the High Court says is again very interesting. First thing that the High Court says was cannot be accepted. Second thing is that under the marriage system, doubting your wife, or let us say husband, or for that matter spouse, goes against the aspect of marriage itself. Did you understand that? Over here we said the call records are being taken out from the wife. That means you're doubting your wife, or so that matter reverse can also happen, right? That means in this particular case, doubting your wife, that means doubting your wife and investigating or spying on your wife is against the law of marriage or the relationship of marriage. So spying on spouse is against the principles of marriage. So that is why also this another thing was stated. So this basically meant that this case over here, the records that have been given or evidence have been given which violates the right of privacy and going against the principle of marriage, so we will not admit it. So we'll be discussing these topics as more and more editorial comes. We'll be discussing them, but this is what the case you should be keeping in mind. The High Court judgment has been there. Possibly this can be challenged in the Supreme Court also. We'll be seeing that. Okay, let's move ahead. So again, Vivek Debroy, we have been reading about him from years. He was a very intellectual man. He was a chairman of the Prime Minister's Economic Advisory Council. He died. So for here, okay, there were various reports also he published. Those are, we read for civil services also. But here, what is important is, what is PMAC? PMEAC, just important from the GS3 perspective, can be asked in your prelims also for that matter. Let's see that. PMAC is basically a non-constitutional, non-permanent, an independent body constituted to give economic advice to the government of India, in particular the Prime Minister. The council serves to highlight key economic issues facing the country from a neutral viewpoint. So that means they present a neutral viewpoint. Whether certain issues are going wrong, they need to highlight them, present it in front of the government and tell them to rectify what. So it is an advisory group also, in a way you can say that, right? So when we talk about history, PMAC has constituted several times since independence. So it is not that the present government has constituted it. It has been there since independence in various forms. But the present form, please understand, the latest occurrence was basically revived on 25th of September 2017. What is the organization? See, the PM Act is chaired by a chairperson. The chairperson was Mr. Vivek Debroy, who had basically expired and died, and consists of eminent economists as members. There are also full-time members and there are other part-time members also who are there. So it has both. Along with it, it has a, let us say, administrators and officials also who are there to help and guide the whole system of PMAC. Nodal agency, this is very important. This can be asked in your prelims also. For administrative, logistic, planning and budgeting purposes, Niti Aayog serves as a nodal agency of PMAC. So they can ask you, what is the nodal agency of PMAC? It is the Niti Aayog. Clear? Not the Prime Minister's office. Please understand that. Functions: analyzing any issue economic otherwise referred to by the Prime Minister, advising him thereon, addressing issues of macroeconomic importance, presenting views to the Prime Minister. This could be either suo motu. Suo motu means that itself the PM Act thinks that this should be highlighted in front of the Prime Minister without the Prime Minister himself asking for it. Or in the case, Prime Minister can otherwise ask also that I need some information, then in that case also PM Act will work. Then you have, let us say, submitting periodic reports to the Prime Minister on macroeconomic development and issues, attending to any other task that may be desired by the Prime Minister. So it means from the economic developmental aspect, whatever issues that they feel should be highlighted and discussed and presented in front of the government or the Prime Minister, or for that matter, Prime Minister asks for certain matter, that you analyze that and tell me how it can work, how it can be implemented. Those things can also be there. So it is a very, it is again depending upon situation to situation, a very dynamic group, because everyday dynamic situations, economy is dynamic. It is changing every day. So for every issue, this is a group which is advising the Prime Minister. Next, so there are certain reports. These are periodic reports which keep on coming periodically: economic outlook and the review of the economy. Now, these are certain periodically come. There are certain other research papers which keep on coming. You would be seeing that the performance of the states also, we had mentioned in front of you that the performance of the states with respect from 1960s to 2023, we had discussed in the last lecture. That is also a report by PMAC. Along with it, there are other reports: agroforestry, missing trees of the forest. So many other reports are there which keep on publishing, or the research papers keep on publishing by PMAC, right? So let's move ahead. Next is COP16. We have already discussed this CO16 few days back, but let us take an overview and then see what the article is saying. This is relevant from the perspective of GS3. It was mentioned in page number 5. Now please understand, COP16 is taking in Colombia. Now what it basically says is, this article says that India expects to spend close to 81,664 crores from 2025 to 2030 in conservation of the biodiversity. Along with it, between 2018 to 22, India has already spent close to 32,207 crores on conservation of the biodiversity. Now you realize that if this target, this humongous target of such a large amount has to be spent on the conservation of biodiversity, it cannot be done from the pocket of the government alone, right? They need India needs international support for that. So what is going on is the government of India mentioned that international finance would be necessary to meet the goals, right? Now this is the agenda. As it goes on, we'll be discussing in detail. Plus what we need to understand over here is again the COP16. Now see, COP16 over here, COP16, please understand, is taking place under what? I'm giving you a brief idea about that and understand it. The goals under the United Nations Convention on Biological Diversity, CBD, right? Under CBD, we realize that these are the goals: conservation of biological diversity, sustainable use of component of biodiversity, and fair and equitable use of genetic resources. We've already done this. I'm just repeating it. For each of these goals, there have been certain targets or protocols. For protection of biodiversity, we have COP meetings, and there was the IKE targets. We'll see that. These other things we'll be discussing when the time arises, but we realize for safe use of biotechnology, we have the Cartagon Biosafety Protocol, and stop the unfair use of genetic resources, we have the Nagoya Protocol. Few days back, I had already discussed both of these protocols in detail. So please have a look at that. Coming back over here, please understand, under the Convention on Biological Diversity, which aims to protect the diversity, this goal is met through, let us say, the IKE targets and the COP meetings. Under the IKE targets, what are these IKE targets? Strategic Plan for Biodiversity Conservation from 2011 to 2020. This was decided in COP, Conference of Parties, that was a meeting. COP meeting 10, right? COP meeting 10. Under that, IKE targets were decided so that how you can conserve a biodiversity. But you realize that there were 20 targets over here. Under these 20 targets, what happened is, because it was a COVID time, these targets were not being able to, were not achieved. What happened? We had to revamp it, right? So what happened? We had the Kunming-Montreal Global Biodiversity Framework, GBF, which was basically, again, the 15th Conference of Parties, COP15, to the UN Convention of Biological Diversity. This took place in 2022, right? Again, repeating, COP10, we have the IKE targets, right? That means till 2020, what you had to protect and how you had to protect, but we were not able to achieve because of COVID issues also. So revamping had to be done under the CBD. So what happened? We had COP15 in 2022, where the Kunming-Montreal Global Biodiversity Framework came out. The aim was to protect 30% of the planet by 2020 to reverse the ecosystem degradation. And the target is, a framework had 4 goals and 23 targets that need to be achieved by 2030. It will replace the IKE biodiversity targets. That means because IKE targets were till 2020, so we needed something fresh so that we can aim at. So we came with GBF, that means the Kunming-Montreal Global Biodiversity Framework. Now this replaces the IKE targets. So what is the target by 2030? So we have a lot of targets over here. 23 targets are mentioned over here. Along with it, goals like conserve, restore biodiversity, share benefits, enable transformation and change. I would request you to please download the PDF from my Telegram account. We cannot discuss all these here because there's a small written in brief. Download it, read it properly again and again, because you can be asked questions on this, right? So ensuring restoring biodiversity, ensure sustainable use of biodiversity, share equally and fairly, enable transformational changes. So again, there are 23 targets under this for conservation of the biodiversity. Clear? So this is something that is a follow-up to the IKE targets or the goals that were there. Now comes the issue. Please understand that in order to achieve these, after COP15 that happened, we had the goals and the targets. COP16 is with respect to how you need to finance these also in order to conserve the biodiversity. That is why India is talking about the aspect how much money is sent. So India spells out finance needs for the biodiversity. So it is basically a follow-up from the COP15. because after COP15, after 2 years, we are having a COP16. So how you going to go ahead with it? That is being discussed, in which India is raising the concern for the financing aspect. That is very, very important. That is why this has been mentioned over here. Clear? Let's move ahead. Now comes your Methane diplomacy. Now, please don't get confused. This COP is under the United Nations Framework Convention on Climate Change. That COP was under the United Nations Convention for Biological Diversity. Please understand here. See, this COP, Conference of Parties, is basically, let us say certain convention is there. Under certain convention, we have certain meetings there, like countries heads are coming, or let us say countries basically send their representatives. So those are the parties who are basically the stakeholders, and they're discussing. Under each convention, we can have such type of conference of parties. This COP 10 had IKE targets under CBD, that is Convention on Biological Diversity. Now we are having what? COP 16 under what? Convention on Biological Diversity. But similar other conventions also exist. Like we have United Nations Framework Convention on Climate Change. Under this, they will be having their own set of COPs. So this COP is different. So do not get confused with that. That is for biological diversity and conservation. This is for climate change. Clear? Let's understand that. Zeroing on methane diplomacy at COP29. Before we go ahead, let us understand certain things. For biological diversity, we have the United Nations Convention for Biological Diversity. But for climate change, we have the United Nations Framework Convention on the Climate Change, UNFCCC, right? It is an environmental treaty which seeks to reduce the atmosphere concentration of the greenhouse gases with the aim of preventing dangerous anthropogenic interference in the Earth's climate change. It was signed in 1992 at the United Nations Conference of Environment and Development, also known as the Earth Summit or the Rio Summit or the Rio Conference. The framework which requires individual participating countries to commit stabilizing greenhouse. That means it is required that how the countries are going to participate and reduce the greenhouse gases to reduce the impact of the climate change, which is a reality now. There are 197 parties. Parties, that means members. That means meeting of their members is conference of parties. Similarly, under every convention, under United Nations Convention for Biodiversity, also they have their own COPs. Under this also they have their own COP. Because why different? The reason is that was for biological diversity, conservation of that. This is in a climate change. So there is a definite agenda for every convention. That is why they have their own COPs, right? Who meet annually in conference of parties to assess the progress dealing with the climate change. So what we are talking about, COP29, is under UNFCCC, right? Okay. Objectives of UNFCCC. Convention ultimate objective is to achieve stabilizing the greenhouse gas concentration in the atmosphere that would prevent dangerous interference with the climate change. So that means they're basically focusing on stabilizing the level of the greenhouse gases. The objective is qualified that it should be achieved within a time frame sufficient to allow ecosystem to adapt naturally. That means within a time frame they should be achieved so that the ecosystem themselves adapt to them and basically survive also. It should be not that we take a target of, let us say, 100 years and by that time the ecosystems are themselves dead, they cannot recover or recuperate. So that should not be there. So basically it is linking the aspect of greenhouse gases and linking to the aspect of ecosystem also, because they are intricately linked. Okay. Now see, let us come. We have understood what UNFCCC is, and we know that under that we have the COP29, the meeting concerning the climate change. Over here what happens is, from November 11 to November 22, COP29 under the UNFCCC will be taking place in Baku. That is basically Azerbaijan's capital. Now it is taking place over there. Now please understand. In this, please understand what is going on. New climate finance goals would be discussed. How we are basically going to finance these, because we are expected to, the countries are expected to see lessen the greenhouse gases. For that, new technology is required. For that, again, a financing is required. So, new collective qualified goals, NCQG. This is again new term that has been given. We'll be seeing them also as the meetings goes over. So new finance goals, under how the financing is to be done, what are the goals that the countries are going to present with respect to that, what are the various dimensions associated with that, that would be presented under new collective quantified goals. We'll be seeing that as the meeting starts and we get more details about that. Over here till that, it was fine. Why the concept of methane diplomacy is mentioned here, that becomes important. Please understand, methane is one of those gases which is a major contributor to the greenhouse effect, right? That takes place. The temperature rise that is taking place. So greenhouse methane is a major contributor, right? Methane, CH4, denoted by a chemical formula. Now, please understand methane. That is why if we want to resolve the problem of climate change, we need to focus on methane, is what the article is saying. Now, the methane is 30% of the global warming impact. Please understand that. And along with it, 20% of the global warming potential, 28% times, just a minute, 28 times the global warming potential than the carbon dioxide if we take a framework of 100 years. Repeating it again. Methane contributes 30% to the global warming, and it has 28 times more potential than carbon dioxide with respect to global warming if we take a period of 100 years. So that means 28 times more threatening than the carbon dioxide. So we are basically saying cutting methane, that means, is very, very important. So reducing the impact of methane or the prevalence of methane again becomes very, very important for us to achieve the goal under the climate change. Now, common ground on methane with respect to US and China. Please understand, the good thing is that US and China both are agreeing to the fact that the methane, a curb on the methane should be done through various dimensions and activities, economic activities that are taking place. So at least the good thing is they are agreeing to that, right? So next is, if we see overall with respect to the methane emission, India ranks third after China and United States. So even China and United States have more emission than India. So India also agrees to the aspect that methane emission should be reduced. But good thing is that US and China are also there. So possibly some fruitful targets can be there. As we move ahead, please understand India. These things very, very important for your prelims also. In India, what are the major contributories to the methane gas emissions? Agriculture 74%, waste 14%, energy 11%, industry approximately 1%. So that means agriculture is a major contributory to the methane gas emission, right? Further along with it, the United States and European Union are also working together to reduce the methane gas emissions. Like European Union and US have basically set a target of reduction of methane gas emission by 30% by 2020 from the 2020 level, by 2030 from the 2020 level. So that means they are further moving ahead with the targets towards reducing the methane gas emissions. Now, when we talk about India, please understand, when we talk about agriculture, waste and energy, these things are majorly contributing towards the methane gas emission. So government of India has also taken various steps. We have the Govardhan scheme. So in order to convert it into energy, we have the Swachh Bharat mission to improve the solid waste management. We have the National Mission on Sustainable Agriculture so that we can reduce the carbon footprints and also the methane gas emissions. Similarly, the National Livestock Mission also aims at streamlining the livestock in respect to the productivity and reducing the methane gas emissions. So Government of India has also its own set of schemes that are there towards this goal. Along with it, now please understand, we now know that we are focusing on climate change under UNFCCC, where the COP29 is going to take place. Over there, we know that methane is a major issue, where we know India, China, and United States are the major contributors to the emissions, and we know that it is a major contributor to the climate change. So why methane diplomacy becomes important is you have to decide and work on how you can reduce the methane gas emissions through, let us say, technology upgradation, through sharing of technology, through cooperation. And over there, please remember again, discussion with respect to financing, cooperation becomes very, very important. So this is what is mentioned in your editorial. Let's move ahead. Prelims topics. GST receipts grows picks up of the target. Please understand, we are not here discussing what is GST. That is known. What is important from the prelims perspective is, please see. In the prelims, what they ask is that there has been a continuous increase in the GST collection from the past 2 years, or let us say from the past 1.5 years. These type of statements come. So that is why when you see these graphs, now please notice it carefully. Do you realize this? In September it has gone down, October it has risen. In, let us say, close to January, February, in the month of January, February, it was 2,10,000 crores over here. So that means there has been an ebb and crest in the collection of the GST also. So there has been no uniform system. So you see it has, okay, a little bit gone up, then again down, down, up, down. So there's a trend. Obviously, overall, there has been rise, but we realize that there have been ups and downs. This is what is important from the perspective. Please understand, in October, collections surpassed 1.87 crores. Large variation exists. Now, this is again a dimension. Uttarakhand flat year on year. That means in Uttarakhand, there was no increase in the GST revenue collection. Northeastern states show a sharp shrinking of the GST. Kerala, highest growth. That means there was 20% growth in the GST collection from Kerala. Then followed by Gujarat. But the issue over here is that though we are seeing little bit rise, this is not meeting the expectation, the goal that Government of India has. Why? The budget 2024-25 factored a rise of 11% rise in the net revenue level, but the revenue growth is not meeting the expectation. Over here, this was just merely 9%. In other cases, that we see that it has fallen also here. So what the expectation is not meeting the requirements, what the expectation of the government is. Obviously, then what will happen is, then we, in the budgetary targets that we are not able to achieve that amount of revenue, then that creates a problematic situation. Obviously, the issues of high inflation, money taken out from the market and being spent in now China by the foreign portfolio investment, all these dimensions are basically impacting the GST also, because the macroeconomic conditions right now are certain dimensions are being seen at the ground level, right? So we see that in this, there were certain reports also with respect to spending on items when this Diwali also decreased because inflation was there. So those things also need to be factored in with the people spending money. Are they spending that much money or not? So these things need to be factored in, and that is why we see the GST aspect also, dimension also varies up and down. So this is something that you should be a little bit aware of. Okay, let's move ahead. 99 cities, GS topic 2, GS 3. Though it is prelims, it is important from the topic wise. I am taking from the mains perspective. GS 3, air quality index. 99 cities record poor air quality index after Deepavali. We know that little bit knowledge about the air quality index should be there. Air quality index is a tool for effective communication of air quality status to the people in terms which is easy to understand. It transforms a complex air quality data of various pollutants into a single number. That means, in order for us to understand what is air quality, it basically tells us that this is a number and this is the quality. So easy for the people to understand. Six AQI categories are there: good, plus, satisfactory, moderately polluted, poor, very poor, severe. Each of these categories is decided on the basis of the ambient concentration of the pollutants that are there. For the 8 pollutants, PM, particulate matter 10, particulate matter 2.4, NO2, SO2, CO, ozone, NH3, and lead. So these are the factors, right? For which are up to 24 hours data is provided here. So these are the pollutants, 8 pollutants and 6 categories, and air quality index is there. Now see, good, satisfactory, moderate, poor, very poor, and severe. These are the categories over here. Just little bit idea should be there. You can be asked. They can ask you that 7 categories are there on the 6 categories. 9 pollutants are there. No, that is wrong. 8 pollutants are there. So this is a certain things that you should be aware of, right? Okay. Nilgiri Biosphere Reserve. Now this was type of an editorial that was mentioned, but it was not relevant from the civil services perspective because it is like a storytelling that had been done. For us, what is important is the Nilgiri Biosphere Reserve that is there. So let us see certain dimensions associated with that. I've highlighted certain stuff. Nilgiri Biosphere Reserve includes the Nilgiri Subcenter. It is a UNESCO World Heritage Site, which includes the Mudumalai, Murukti, Nagarhole, Bandipur, and the Silent Valley National Park, as well as Aralan, Wayanad, and Sathyamangalam Wildlife Sanctuary. So all these are part of the Nilgiri. This can be asked in your prelims as well. Vegetation of Nilgiri Biosphere Reserves are mountain, sholas, and the grasslands at the high altitude, semi-evergreen, moist deciduous forest, dry deciduous, tropical evergreen forest. We'll be seeing this in detail after this slide, don't worry. Major fauna are, this is lion-tailed macaw, Nilgiri tahar, Malabar giant squirrel, Nilgiri langur, etc. And there are various tribes also: Todas, Kotas, Irulas, Kurumbas, Paniyas, Adiyan, Adinandan, Chettis, Alar, and Malayan. So these are certain tribes. Now let us see certain dimensions in detail. One should understand that these are the Nilgiri Biosphere Reserve is spread in 3 states. Now this can be asked to arrange them in order which state has a major area. Now please understand, Tamil Nadu has the largest area. Second is Karnataka. Third is Kerala. This should be very well asked. They can be asking you the order: Tamil Nadu, Karnataka, Kerala. You need to remember this order. Next, vegetation. Again, I have what we had discussed in that in brief. This is in a little bit of detail. Vegetation: moist evergreen, dense moist multi-stolid forest are there in the Silent Valley region. Semi-evergreen, moist deciduous, thorn dense, savanna food, trees scattered among woodland, sholas, high elevated greenlands and grasslands. So these are things, basically an explanation of what we had done just now. Now, as we move ahead, let's see this topic. Topic 4, page 9. Now, North Korea boasts of the world's strongest missile. This is Wangsong. Many people pronounce it differently. H is silent, so it is basically Wasong also. So Wasong 19. Now, please understand what it is. It is an intercontinental ballistic missile. It is around 92 feet tall, and the instance is that even the intercontinental ballistic missiles of United States is also approximately 66 to 67 or even 70 feet long. This is 92 feet long. That is why North Korea is saying that this is the strongest intercontinental ballistic missile. In the test that took place, it traveled to 1001 kilometers and flew for 86 minutes. And this is something huge. Please understand that now we do not know the exactly. It has, let us say, a liquid fuel, or let us say a solid fuel. Now, this is a certain presumption. That is why I pasted a photo based on the United States, a news in the United States. What it says that the color and shape of the exhaust flames North Korea state launch suggests that the missile uses preloaded solid fuel, which makes the weapon more agile and harder to detect than the liquid propellants in general must be fueled beforehand. So it is presumed that it is preloaded with a solid fuel. So this is something you should know. Okay, let's move ahead with the MCQs. Okay. First question. Second question part. Pause the video, attempt it. The statements. Third question. Statements. Fourth question. Attempt it, please. Fifth question. MCQs explanation. 1 is B, 2 is B, 3 is B, 4 is A, 5 is C. So this was the analysis of the Hindu from 2nd of November. Hope you liked it, enjoyed it, and learned something new. Take care. God bless, and Jai Hind.